the examination of the Brentwood local plan pre-submission document dated February 2019. We're going to be calling that the plan. So if you hear us referring to that, that's what we're referring to. Now, my name is Yvonne Wright. I'm a Chartered Town Planner and a Senior Inspector, and I'm here with my colleague, Mr. Mike Warden, who will, I'll just get him to put his camera on and his mic on and just introduce himself.
Hello, everybody. Can everybody see me and hear me? Thank you. Good morning.
Yes, thank you. Now, we've both been jointly appointed by the Secretary of State under Section 20 of the Planning and Compulsory Purchase Act 2004 to hold this examination into the legality and soundness of the plan and to produce a report for our conclusions and recommendations on these matters. As you are fully aware, Annette Feeney is the Programme Officer. You will all have spoken to her, obviously, before joining the event today. Now, she's working independently from the Council at our direction and is responsible for the administrative and procedural arrangements for the examination. So please, if you have any questions or queries on those matters, please direct them to Ms. Feeney. Just a reminder, you're all fully aware, I'm sure, but all information is available on the examination webpage. Any necessary updates are going to be posted there, so please ensure you keep an eye on that. I'm sure also you've been all very vigilant in looking through our guidance notes. We've got the main guidance notes and then the virtual event guidance notes that we've produced. Just a couple of reminders just to assist us during these extraordinary times of having virtual events. Please ensure that your microphones are on mute. That helps, unless obviously you're invited to speak or you need to ask us a question because you're not understanding something, because that helps to prevent disturbance from background noise, etc. Now, we're fully aware, a lot of us are all in our own homes, etc. There are bound to be some distractions that will happen. Don't worry about it. I will probably wait for my dog to interrupt me, but hopefully not. But it also limits any sort of microphone feedback and that if there's other devices and things around or other distractions. Please, can you also ensure that all your mobile phones and electronic devices not being used for the virtual event are either switched off or on silent, please, just so that we don't get lots of phones ringing. Please also remember, if in the breaks you put them back on, please turn them back off after we resume after a break. And then obviously, if you do wish to contribute to discussions or have any queries through the session, if you can use the raise hand function, that would be really useful. Now, our role is to assess whether the plan satisfies relevant legal requirements and to independently examine the soundness of the plan under the 2019 version of the National Planning Policy Framework. We will refer to that as the framework or the NPPF. In order to be sound, the framework states that the plan should be positively prepared, justified, effective and consistent with national policy. Now, our MIQs are focused on these requirements, and as will our discussions during this hearing. So if participants can try and focus on those elements, we would be most grateful. Now, in terms of the outcome in relation to soundness, there are three possible outcomes to the examination. For clarity, I'll just reiterate them here, just in summary. We could find that the submitted plan is sound and that no modifications are necessary, but from what we've read so far, from the Council putting forward suggested amendments, that's not going to be an option in this case. Another option could be that the submitted plan is not sound but could be made sound by making changes, or the submitted plan is not sound and could not be made so through any changes. Two ways that we can make these changes to the plan. There are main modifications, which are recommended by ourselves, and additional modifications, which are made by the Council on adoption. Sometimes those are called minor modifications, but formally they should be called additional modifications. The Council has formally requested that we recommend any main modifications necessary to make the plan sound. However, we can only recommend main modifications if they are necessary to resolve problems that would otherwise make the plan unsound. Main modifications are changes that would materially alter the plan or its policies. In the interests of fairness, they will need to be subject to consultation, which will obviously be after the hearing sessions have finished. and further sustainability appraisal and or appropriate assessment under the Habitat Regulations assessment may also be necessary. Just to clarify, additional changes which do not materially affect the policies in the plan. They are made by the Council on adoption and don't fall within the scope of this examination. The Council is purely accountable for those. Generally, they involve factual updates or corrections of typos or errors. However, where we consider any proposed additional modification put forward by anybody does in fact materially affect a policy, we will discuss this within the hearing where relevant. And obviously, if it is going to affect those policies materially, they would have to become a main modification if it affects soundness. The Council has produced a number of documents where they've made suggestions for changes. This includes their addendum of focus changes, which was produced in October 2019. That's document A2. Also, since submission and in response to our initial questions, the Council has suggested other potential changes to the plan. These are set out in documents F9A and F9B, and again, they've split them into what the Council considers are potential main modifications and potential additional modifications. Now, obviously, these are not formal main modifications at this stage because these are not main modifications that we've recommended, but obviously we will consider these as part of the hearing sessions. Obviously, as well, some participants have also recommended further suggested changes, and again, throughout the hearing, we will be looking at those and seeing whether they are necessary for soundness. As the hearing progresses, it would be really useful if the Council could just prepare a running schedule of any main modifications that come forward. That's won't be in addition to what the Council has called main modifications. That's a separate list at this stage. So just in terms of looking at the procedures that we're going to be following during the hearing sessions, again, just a reminder, we have set these out in our notes, but just a quick reminder that the purpose of these hearing sessions is for those invited to participate to help us with our task of examining soundness and legal compliance. So obviously, it would be really useful if you can contribute in terms of those discussions during the sessions, please. Hearing sessions will be in the form of structured discussions, which we as the inspectors shall lead, following the questions set out in our MIQs. Now, either Mr. Warden or myself will lead each separate session, and to provide clarity during the sessions, the non-lead inspector for that session may well have their camera off. It may not be necessary for them to have their camera on all the time, unless they obviously wish to contribute to the discussions. But please be assured that both of us will be present at each session. Now, we've divided the sessions up to allow more focused discussions on key points that we feel get to the heart of either legal compliance or soundness, but accept that there will inevitably be some crossover between some sessions. So particularly this week, there is going to be some crossover in relation to when we discuss sustainability appraisal, etc., and the spatial strategy. It's all interlinked with elements when we start discussing Greenbelt and the spatial strategy, etc. So, but it's just a reminder that more detailed matters, particularly on site allocations and policies per se, will be discussed during later hearing sessions in February. Obviously, we do have matter 6, which is next Friday on the 11th of December, which is starting to discuss the Garden Village allocation. But we want to try and focus on that day on the more strategic elements relating to the Garden Village. And then we have further sessions for more detailed matters on the actual policies themselves. On that note also, so please remember that we're not here to discuss any emission sites. I know some of you are probably clamouring to have a chat about those, but they're not in the plan and they're not before us. So please remember not to bring up emission sites that are not within the plan. Obviously, we will inevitably discuss different land areas when considering some strategic matters. That's going to be inevitable, particularly this week, including when we discuss matters relating to the spatial strategy, the sustainability appraisal and the green belt. But this is not an invitation to discuss a specific emission site. Please also note that we're not necessarily proposing to go through every single question from our MIQs, our matters, issues and questions, as there may be some issues where we now feel that we've got enough information, so there may be little or no discussion. However, we will state that in the sessions, just to give anybody a chance to comment if necessary. Excuse me. Now, in terms of timing and the general length of sessions, it may be necessary for there to be a degree of flexibility in terms of the length of the sessions. Morning sessions will always start at 9:30 and afternoon sessions will always start at 2 p.m. Now, there's one day at the moment this week, which is on Thursday, where we have 2 sessions in the morning. So one will start at 9:30 and the second session in the morning will start at 12 o'clock. So please ensure that you check the programme and make sure that you attend at the right time. Lunch would generally be between 1 and 2, and we propose to sit each day until around 4 o'clock. It may be shorter, it may be later. It all depends on the sessions and how the discussions are going. However, I do want to ensure that we don't go too long after 4 o'clock, possibly up to about 4:30, because obviously if people have caring responsibilities, that could be an issue. And also, I'm not convinced we can all stare at a screen all day, to be fair. So I think we will need some comfort breaks and some time away from screens. However, where necessary, we will not go beyond 5 o'clock. That's our absolute deadline, but hopefully it will be before that. We will obviously be taking appropriate breaks mid-morning and mid-afternoon. The mid-morning one will usually be for half an hour around, we'll start usually around 11 or around that time. The afternoon one, we will decide depending on how those sessions are going. In terms of site visits, we will carry out site visits where we deem these are necessary during the examination, and we will either do that, well, we would do most of those unaccompanied, or we do not anticipate we need to have any accompanied site visits at the moment. However, if we do need to access private land, then obviously we will discuss those in the sessions. Now, in terms of evidence, this should already have all been submitted by everybody, and we will not be accepting any further documents, letters or written submissions of any kind during or after the hearing sessions, unless we specifically request it. After the hearings, the examination does remain open until we have published our report to the council. Now, are there any specific questions on what I've said today, this morning? No, I can't see. No, there's shakes of heads, so that's fine. Oh, that was a, oh, Mr. Banner.
Sorry, madam. I had and good morning, Charlie Banner for EASL. So I had a bobbing hand there. Just one point about documents, madam. I drew to your attention, which you may or may not have seen through Annette yesterday. There's been a very recent judgment on the duty to operate in relation to the Sevenoaks plan, a judgment of Mr. Justice Dove, which does contain some comments which are of broader application. It seems to me it would be sensible for you to have regard to it, if only for your own benefit, and to de-risk the process from your point of view. It's not evidence.
I have read that judgment. Yes. Excellent.
Well, in which case, if you're familiar with it, you don't need to be provided with it. I'm grateful for that indication. Thank you.
Thank you. I think because that has been raised, though, it's a public document. I'm happy for that to be included as part of the examination evidence base, because it's not really evidence, it's a judgment. So that can be provided so that people can read that at their leisure. So I'm happy for that to be provided.
Thank you. Thank you very much.
Thank you. OK, if there's nothing further, can't see any other. I'll just check that there's no other hands up at the moment. No, there aren't. OK, can I then ask the council to make their opening statement, please? Thank you. Is that Mr. Drain who's going to be doing that?
Yes, thank you, Inspector, and good morning, everyone.
Thank you.
Opening statement from Brentwood Borough Council. My name is Phil Drain, and I am the Director of Planning and Economy at Brentwood Borough Council. I've worked on the preparation of the Brentwood Local Plan since 2006. On behalf of the Council, we welcome this independent examination of the Brentwood Local Plan. This milestone has been a long time in the making. Over this time, several consultation stages have shaped decisions on how best to achieve a challenging requirement, how we can best meet increasing development needs in a highly constrained borough. 89% of Brentwood Borough is within London's metropolitan green belt. That equates to everything other than the Brentwood urban area and most villages. For past Brentwood local plans, there has been a reliance on the redevelopment of brownfield land, such as former hospitals and industrial sites. This maintained the green belt intact. However, such land is finite, and so large site brownfield land supply has reduced. The green belt has helped to maintain our core character. We are a borough of villages, set around the market town of Brentwood and surrounded by rolling green countryside. This character plays an important part in why the borough is an attractive place to live and work. It is also a priority for residents that this character is protected, often meaning difficult conversations about how growth and change can be accommodated. The borough is well connected to London and surrounding transport infrastructure. The presence of two transport corridors running through the borough, one in the centre and one in the south, has influenced development in the past. We recognise the strain on existing infrastructure and facilities as places have grown over time and investment has not kept pace with growth. The borough is a self-contained housing market area with clear groupings of authorities and areas surrounding us. This plan deals with Brentwood Borough's housing and other needs. The borough's characteristics are fundamental to the strategy of growing to meet development needs in a sustainable way that is, so far as possible, consistent with local character. This balance has been a key part of the strategy for growth. The Brentwood Local Plan is an overarching plan for the borough to 2033, setting out a vision, objectives, strategic and non-strategic policies to manage development. It seeks to meet growth by first utilising available brownfield land, including efficient use of sites at appropriate densities. Recognising that local development needs cannot be met in urban areas alone, it then identifies extensions to urban areas within Greenbelt that are contained by defensible boundaries. Finally, in order to bring forward development at a scale that delivers local community facilities and supporting infrastructure, and in line with our local village character, it proposes to allocate strategic growth at Dunton Hills Garden Village and Brentwood Enterprise Park. Overall, this growth equates to over 8,000 new homes and around 6,300 new jobs. Dunton Hills Garden Village will provide for around 4,000 new homes beyond the life of the plan, supporting employment and community facilities with open green spaces flowing through its heart. This new community will add to the collection of Brentwood villages. It will help unlock our vision for advances in the use of sustainable transport through links and improvements to West Horndon Station. Much work has been undertaken with partners such as Homes England within an approved governance framework. This followed the government designation of Dunton Hills as one of the first wave of garden communities across the country. Brentwood Enterprise Park is an opportunity to react to changing business needs by providing a significant amount of new employment land close to the strategic highway network, integrated within the wider sustainable transport vision. This utilises brownfield land within the Greenbelt. We know that no local plan is perfect. The Brentwood plan has been prepared over a long period of time and within a changing planning context, seeking to balance several complex issues. Fundamentally, the priority has been to meet development needs consistent with local character. This strategy is evolving and development needs are likely to continue to rise. With this in mind, we are keen to engage with the inspectors on any necessary changes required to make the plan sound and repeat the intention that the plan will be immediately reviewed to consider needs beyond 2033. Wider cross-boundary strategic planning will assist this review process through joint working on the South Essex Joint Strategic Plan. However, our local plan review process is not dependent on the Joint Strategic Plan. Earlier this year, the Council adopted a new corporate strategy to 2025. The strategy sets out several themes and objectives, prioritising the need to grow our economy and deliver new homes. Specific mention is made of the importance of adopting a new local plan and delivering Dunton Hills Garden Village as part of overall corporate aims for strategic growth. The local plan provides an essential vehicle to underpin and assist in delivering many of the Council's corporate objectives for the economic and environmental goals. Plan making in the southeast of England is difficult, particularly for those authorities within London Metropolitan Greenbelt. Development needs are high, but land supply and infrastructure capacity is limited. When considering plan making in the wider area, the Basildon Borough Plan has been undergoing examination for over 18 months. The Epping Forest District Plan has been undergoing examination for over 2 years. Thurrock Council plan to consult on Regulation 19 stage in 2023. Chelmsford City Council has recently adopted a sound plan with the aid of non-Greenbelt land to accommodate the majority of new site provision. The London Borough of Havering are working under the framework of the London Plan. Delivery of much needed growth is stalled by various complex issues: protection of Epping Forest, air quality implications, and the Lower Thames Crossing, to name a few. The Brentwood local plan looks to deliver much needed growth following formal and informal engagement with local communities, stakeholders, and other partners. It is important that we can get a plan in place now to deliver much needed new homes and jobs before considering longer term needs. We are grateful to our many partners involved in progressing the plan, including adjoining local authorities and Essex County Council. Whilst we may not always agree, we are all trying to plan for the future benefit of our areas and the continued prosperity of Essex. The Council's planning policy team will be predominantly representing the Council at this examination. The team is made up of Jonathan Quilter, Strategic Planning Manager, Andrea Pearson, and Tom Hong, Senior Policy Planners. We are supported by colleagues across the Council and our counsel, Paul Shadarivian, QC, as well as a selection of specialist consultants. This concludes the Council's opening statement.
Thank you, Mr. Dray. Now, on that note, I would, unless there are any queries or questions in relation to the introductory statements that have been made, I'd like to now move on to matter 1, issue 1. So are there any? I can't see any hands up, so no queries or questions. Okay. Now, to start off with, what I'd like to do for matter 1, issue 1 is for everybody to introduce themselves, please, so I can ensure that I've got everybody around the table that is supposed to be here. So can I start with the Council, please, to just introduce themselves?
Yes, ma'am. Sir, my name is Paul Shadarivian, QC, and I represent the Council. I'll encourage other members of the team to do so individually so you recognise their faces.
Lovely, thank you.
Good morning, Inspectors. Jonathan Quilter, Strategic Planning Manager at Brentwood Borough Council.
Thank you.
Good morning, Inspectors. My name is Andrea Pearson, Planning Policy Officer at Brentwood Borough Council.
Thank you. And then you have, sorry, Council, you've also brought along some technical experts as well, but I won't bring those in at the moment. I think the technical witnesses, if we can bring them in as and when they're required, and then they can introduce themselves, I think that would be easier.
I'm grateful for that. Thank you very much.
Thank you. Thank you. Is Basildon Borough Council here? Is that Mr. Davies?
Yes. Yes. Thank you, Inspector. My name is Robert Davey. I'm a Principal Planner with Basildon Council, and
Lovely.
I'll be speaking today.
Thank you very much. And then do I have somebody from CEG or representing CEG?
Morning, ma'am and sir. As I hope is clear, I'm not Charlotte, so apologies for that. My name is Ian Ginbey, Ginbey, of Clyde & Co. Solicitors, and I act for CEG, the promoters of Dunton Hill Garden Village. Thank you.
Thank you. And do I have Essex County Council present today?
Good morning, inspectors. My name is Mark Robinson, Principal Transport and Infrastructure Planner at Essex County Council, representing Essex as the Highways Authority.
Thank you. And again, there are a couple of other people from your team who are going to be here today, but obviously if they come in and need to discuss, then they can introduce themselves. Okay.
That's right. Thank you.
Thank you. And Estates and Agency, that's Mr. Banner, isn't it?
Yes, madam. Good morning again for a second time, and good morning, sir, to you. Yes, I'm the principal speaker for EA Strategic Land. I'm joined this morning by Mr. Nick Ireland, who's off screen but on the list and will come on screen as and when needed.
Okay. Lovely, thank you. And representatives for Hallam Land Management. That Mr. Hill.
Yes, good morning, ma'am and sir. I hope you can hear me and even perhaps see me. Yes, I appear for Hallam Land today, and I'm joined by Mr. Gary Stevens of Marans Planning, who will come forward as required during the course of today and succeeding sessions. Thank you, ma'am.
Thank you. And the Homes Builders Federation.
Good morning, Mark Barrett from the Home Builders Federation.
Lovely, thank you. And representatives for Tesco's.
Good morning, inspectors. My name's Selwyn Atkinson. I'm an Associate Planning Director with GL Hearn, and I'm attending on behalf of Tesco.
Thank you. And Thurrock Borough Council.
Good morning, inspectors. My name's Richard Hatter. I'm Strategic Planning Manager at Thurrock Council. And I'll be representing the council today. There'll be another witness for the latter session on the SA.
Okay, lovely. Thank you very much. Is there anybody else present who from another organisation? I'm hoping not, because that's who's on my list. So excellent. Thank you very much. Right, so matter one, issue one is on duty to cooperate. So it's all about our particular issue is whether the council has met the statutory duty to cooperate as set out under the relevant legislation. Now, the legal duty to cooperate in relation to planning for sustainable development, to give it a formal title in the legislation, means that the council must have cooperated in maximising the effectiveness of activities undertaken for the preparation of the plan by engaging constructively, actively and on an ongoing basis with those persons listed in the legislation, including the prescribed bodies. So our queries that we've put into our questions relate to, and just to summarise them, whether the council has engaged actively, whether that engagement has been on an ongoing basis, and I suppose quite critically, whether that engagement has been constructive, and that's in relation to outcomes. and overall whether the cooperation that the council has done has maximised the effectiveness of the plan in terms of its overall preparation. Now, the evidence provided by the council demonstrates that there has been engagement with a large number of prescribed bodies, neighbouring authorities, etc. There have been some comments made about, or some queries raised about the number of meetings that have been carried out, the lack of some meetings, and obviously the timing of meetings and when those have occurred in relation to the plan preparation. The main queries that seem to have been arisen through the representations and having looked at the evidence relate to the effectiveness of the engagement and whether it has actually been constructive in relation to outcomes. And therefore, we would like to focus particularly on that particular element of due to cooperate. So it's whether the effectiveness of the discussions has been brought about by constructive engagement. Can I just, Mr. Davey, could I just ask you to just put your microphone on mute, please? I can hear some background noise. Thank you very much, Mr. Davey. I do appreciate that. Thank you. So there are obviously still outstanding objections on due to cooperate. So I would like to go through some of those today, obviously without necessarily completely repeating everything that's been said, because obviously it is before us already. But I want to try and draw out this issue of whether there has been constructive engagement. And there are some concerns as well that have been raised about some due to cooperate objections haven't been put into the relevant council documents as well. I think that's been raised. I think Estates and Agency, you've raised that particular issue. In relation to the objections aren't included in some of the in some of the council's documents. So can I just come to the council first to just, I don't want you to summarise all of the due to cooperate issues evidence that you've produced. You've produced an awful lot on the back of our initial questions, but I would like to just focus on, you've obviously read some of the hearing statements that have been raised and that are obviously before us. This issue about have all of the, well, let's just start with the, has the council taken into account and given us the correct information in relation to all of the due to cooperate comments that have been made by representatives? Because as I said, a couple of some representatives are saying, well, mine's not included in certain council documents when the in terms of, I think it's F3F, I think some where the council has produced their document listing all of the comments received, but some comments are missing. So can I just ask the council who's going to be responding on that point? Will it be Mr. Shadarevian or is it going to be one of the council officers?
I'm going to ask Mr. Drain to do so, Ma'am.
Thank you very much.
Because he has direct experience of engagement over the years.
Thank you, Mr. Shadarevian. Mr. Davey, please.
Thank you, Inspector. Our position is set out within the hearing statements, as you say. Effectively, we have tried to always engage at every stage of formal consultation with relevant bodies, indeed with everyone. If there has been anything that we've missed within F3F, I believe the House Builders Federation comments were for some reason missed, and we republished those. So we have tried to make every effort to make sure that we've published all of the comments that have come in, but certainly on receiving them, we've tried to take account of those issues. And in terms of some of the things that have been raised, in particular by Thurrock Council and others around considering the level of objection that is being raised through the plan making process. we have sought to make sure that we are able to respond to those issues through documentation such as the sustainability appraisal. I suspect many of those issues will come up across the different matters and the sessions that we have.
So in relation to the documents that we've got, there's nothing missing. There's no objections that that we're missing in relation to due to cooperate.
Not that we're aware of, Inspector, no.
Thank you. Mr. Banner, is there anything you want to add on that at all? Do you feel that that because it's not, your comments were not in F3F or the responses in relation to Regulation 19, that do you feel that that has caused concern for your clients?
Yes, madam. I mean, plainly, there's not a legal duty to summarise everybody's, because that would be absurd for me to suggest otherwise. You did ask for that exercise to be done, and there were some inexplicable omissions, including of our representations. It does, I suggest, cast a degree of doubt about the reliability of the picture that's painted by this authority to you both as to what has happened, especially in the context of there being a very real concern about after the event justification, bearing in mind that the duty to cooperate crystallises as at the moment of submission. And as, for example, in the Sevenoaks judgment, after the event, statements of common ground, explanations, etc., saying there's no problem now, doesn't actually address whether there was an issue in relation to duty to cooperate at the time when it applied. So I suggest it goes to weight and general the degree of trust and credibility you can place it in the picture that's being painted to you.
Thank you. Does the council want to, Mr. Drain, do you want to respond back on that, or should we move on?
Thank you, Inspector. It's my understanding, where we've tried to summarise comments, that may be part of the concern that in summarising we've missed elements of detailed objections. But no, I mean, we see the process as ongoing engagement. We understand that the issues that are being raised, in particular with neighbouring authorities, are complex ones. And we have sought to continue to engage with, in particular, our neighbours and Essex County Council to try and resolve those. So I see the purpose of statements of common ground as doing exactly that, as explaining what issues we are discussing, where there needs to be resolution, actions and work that we've been trying to undertake to get to a point of resolution. We've managed to be able to do that with all authorities. We have not been able to progress one with Thurrock Council, as I'm sure we'll come on to, in terms of objections and disagreements about particular elements of detail. But that is what we see as the purpose of continued engagement through the plan making process.
Thank you, Mr. Drain. Mr. Banner, anything further to add? Mr. Banner, your hand is up. Do you wish to contribute?
Yes, I lost the connection there a moment, so forgive me if this point was covered. But just on the statements of common ground, when you come to have a look at the Sevenoaks judgment, can I just highlight a couple of paragraphs? There's paragraph 24, which quotes the Inspector Karen Baker's findings in relation to the relevance and weight to be given to statements of common grounds submitted during the examination, as opposed to
is this paragraph 24 of the Sevenoaks judgment?
It is 24 of the judgment, which quotes 32 and 33 of Karen Baker's decision or findings. And then those findings were upheld by Mr. Justice Dove at 53 and 58. I don't think I need to read anything out because they're self-explanatory and you're familiar with the judgment. So it's paragraph 24 and the quotes, and then 53 and 58. The only other point I just wanted to add, Madam, is, of course, there is this document that's been mentioned that we asked for, that I understand from the correspondence yesterday is going to be provided or put online during the course of today. Which is the report which we refer to at paragraph 2.6 of our hearing case, the final report of the study on strategic growth locations done at the South Essex Authority level, which we suspect probably contain things which should have informed the plan making process and may very well have engaged the duty to cooperate in that context. We don't know because we haven't seen it, but I do ask that we have the opportunity to comment on that when we do see it, because it may be relevant to this issue.
Absolutely. That document has been raised in a couple of hearing statements, including the council's hearing statement. So I am going to allow that document, subject to it being allowed.
Yes.
Because I understood that permission had to be given from each of the authorities. Has that permission been given then?
Yes, Inspector, if I can come in on that. I believe that we are in conversation with Acela Partners, the Association of South Essex Local Authorities, who of course are the owners, the authors, the publishers of that document in terms of when it is eventually published. The intention had been, as part of the plan making processes for many of the authorities within the group, including Castle Point examination coming up, that lots of the evidence that's been produced in recent times would be published at some point soon. So that intention was there, but clearly with the interest of these hearing sessions coming forward, we have asked the group that we may publish that sooner than had originally been intended. I believe that we are able to do that and will do so soon on our website.
Okay. Obviously, there will be no discussions in relation to that document because we haven't seen it at the moment. I know that the programme officer did obtain it last night, but we certainly, as ourselves as inspectors, haven't had a chance to have a read of that. We will be giving relevant participants the opportunity to have a look at that document and respond. Now, exactly how and when, I'm not going to discuss that now. Because I need to have a look at the actual document itself. I don't know how long it is. I haven't, until we have a look at that, we don't know. But we will obviously discuss that later, hopefully later in the week, or certainly later in the proceedings. Okay, thank you very much. Thank you, Mr. Banner.
Thank you.
Now, if I just come back to the council, please. You highlight in your hearing statement the outstanding strategic matters. I think they're in paragraph 7 of your hearing statement, and these are particularly relating to housing, employment, transport infrastructure, greenbelt release and open space and recreation. So you do list those in relation to those matters. Can you just very briefly sort of summarise why those are still outstanding matters? What is that's been holding you back on resolving those particular matters? I don't necessarily want to go into massive detail on particular issues at this stage because we have later sessions on housing, we have later sessions on transport or infrastructure, we have later sessions on greenbelt, etc. But are there particular overarching reasons as to why, from Brentwood's perspective, you've not been able to resolve those issues as part of duty to cooperate? Is that going to be Mr. Shadorevian, or is it going to be Mr. Drain?
Thank you, Inspector. I think that's me. Just to clarify, we're talking about paragraph 7 and the listed bullet points underneath in our hearing statement.
You've listed in there the
Yeah,
remaining
that's fine.
outstanding concerns. Yes, it just gives a very good summary in relation to from your perspective as to what's outstanding. So that's why I wanted to refer to that. Obviously, you've referred to them in your other documents as well, but I thought that was a good summary there. So could you just briefly sort of explain why you've not been able to resolve some of those issues?
Thank you. Yes, it's just helpful to check that we're looking at the same paragraph. Ultimately, with regard to issues such as Dunton Hills Garden Village, we're aware that large amounts of growth being planned through that new community. There are elements of outstanding questions about the impact of growth in particular. We'll as you've already said, we will cover many of these things as we go through the different sessions on spatial strategy and such. With regard to housing, we've set out that being on the boundary with Basildon and Thurrock councils, we have been in discussion with them about the role of bringing forward that growth and how housing can be brought forward in terms of meeting housing needs. So as we'll be getting on to when we talk about those things through use of the standard method and the way in which this plan plans to meet the housing needs of Brentwood Borough, we're just conscious that that site is on the boundary with those authorities. So there is a discussion there about how we all can meet our needs. With regard to employment, I think the issues around housing and employment do point back to some questions about the role of infrastructure in particular and the impact on infrastructure, whether that would be on a range of things, traffic, also just movement of people generally, and the role of local services and facilities. So what we've sought to do is to continue in particular conversations with County Council and Highways England around that transport issue, and thinking through with our neighbouring authorities as well what the wider impacts may be on growth. And of course, I think the issue there is that it's not just related to Brentwood growth and Dunton Hills Garden Village, for instance. This is related to wider South Essex growth, and thereby the need for us to work together, as we've been doing through the Acela partnership, to understand what the wider implications of growth are, and thereby the impacts on particular junctions and roads that flow through our authorities. So that is an ongoing conversation, is part of the reason why we haven't been able to resolve that, because when we're looking at impacts, it impacts so much more widely on the wider area. There are things there that we need to work through with, in particular, our Highways Authority colleagues.
On that particular point, can you just so I can understand the engagement that has occurred with those neighbouring authorities who have raised these issues, and obviously I will be bringing those authorities in to have a discussion about these particular points shortly. Obviously, those issues, Brentwood is not an island, so it has that impact. Anything that happens in Brentwood could have an impact on a wider area, which is obviously, you've just alluded to that. So what I'm trying to understand is what level of engagement has happened, constructive engagement has happened between yourselves and those authorities, because we've got Basildon here and Thurrock who are both saying that Brentwood hasn't taken their comments on board and isn't looking at the cumulative impacts, I suppose, if you want to put it that way, of the effects on their areas in relation to what Brentwood is trying to achieve in its own area. So why have those, obviously there have been discussions, but what Thurrock and Basildon are saying is they haven't been effective in relation to nothing's been resolved. Now, I'm not saying there has to be agreement at all. That's not what the duty to cooperate is about. But it's about sometimes you can agree to disagree. And there doesn't seem to be an agreement to disagree at all. So how has the council tried to resolve that in talking particularly to its neighbours in terms of Basildon and Thurrock? And then I will bring Basildon and Thurrock in to help on this discussion. Is that Mr. Drain again?
Thank you, Inspector. I would say that the partnership that we have through Acela is a key piece when it comes to clearly working with Basildon and Thurrock in particular, just because we're all part of the same group. And the whole reason for that group being created was predominantly down to the role of infrastructure and the capacity of infrastructure to cope with the levels of growth that we're all looking at. So as we've said, and I think we would all agree on, it is a complex issue. And so that complex issue has meant that we've had to maintain discussion through Acela, discussions on the A127 corridor in particular, as we call it, through the Acela group, South Brentwood Grove corridor that we'd called it in our plan, as well as other corridors of transport provision throughout the wider area. In particular, our focus has been on trying to solve Brentwood-focused issues when it comes to specific junctions and issues around investment with the County Council and Highways England, and indeed the rail providers, for instance, Network Rail, C2C, when it comes to West Horndon and other rail provision in the borough. there have been instances where, for instance, with West Horndon Station discussions, we've engaged with Thurrock in terms of the role of that station, that railway line there, and the way in which Thurrock and Brentwood adjoin each other. Our focus has often been on maintaining discussion on the Dunton Hills Garden Village project, just because of the fact that it is, as I've said, on the boundary, and thereby we understand that there could be implications for adjoining authorities, specifically on sort of wider issues such as transport. However, when we've looked at that specific issue, when it comes to impacts on Thurrock, those impacts are limited and can be mitigated. When we've looked at those issues with Basildon, those impacts generally can be mitigated, and the whole point of what we're trying to achieve with development, particularly at Dunton Hills, but in the south of our borough, is to make sure that we're underpinning that with sustainable transport principles, which we've set out within policies within our plan and within our sustainable transport vision that we've set out for the area, so that we are not looking at the worst case scenario that transport evidence tends to consider as a baseline for which you'd need to provide mitigation for. So in answer to your question, our engagement has particularly been focused with highways authorities, but through Acela, we've been talking about the wider transport impacts and the wider need for huge amounts of investment that are required in our transport network with Basildon and Thurrock through the Acela piece, as well as with the County Council. Obviously, we share a highways authority, Basildon and ourselves, and we're mindful that Thurrock are the highways authority on our boundary.
Thank you. On that particular point then, can I bring in, I'll start with Basildon Borough Council, please. So Mr. Davey.
Yes, thank you, Inspector. Can I just check that everyone can hear me?
Yes, we can. Thank you, Mr. Davey.
Great, thank you. Yeah, thank you. So our position on that, really, and I take on board what was just explained by my colleague from Brentwood. It is, I think it's worth starting by saying it is important to distinguish between the legal failure to cooperate and disagreements that result from cooperation. Obviously, the duty to cooperate is a binary pass or fail. So we don't necessarily allege a failure, but I think our position is really that we would have appreciated much greater clarity. From our position at Basildon, we also welcome Brentwood's partnership with Acela, and that will certainly help to satisfy the ongoing aspects of the duty. We just perhaps have a bit of a gap in terms of how we've arrived at where we are now with the local plan. And Basildon's position is really that there was a lack of transparency during the critical plan making stages as a consequence of not having a HELAR in place for 7 years until 2018. And it's not really clear to what extent some of the comments that we made have been reflected within the redrafting of the plan. And the subsequent suite of topic papers that the council produced have also not addressed our questions. Our main concern is around Dunton Hills Garden Village and the lack of infrastructure and the effects it will have on our borough. Quite crucially, our own plan contains up by the borough boundary with Dunton Hills Garden Village. There's just greenbelt land over our side. We don't have any proposals there. So clearly, if we have a situation where with Basildon itself undergoing comprehensive regeneration, we've also got a plan at examination as well. If we suddenly find that our school place projections need to be redone and we need to find land because Brentwood simply don't have the schools capacity in their borough, what do? It poses questions, but also
sorry, Mr. Davey, for interrupting, but have those questions been asked of Brentwood in relation to? I mean, we're starting to move into soundness issues here, and I do want to bring it back to legal compliance in terms of due to cooperate. But I just want to understand what conversations have happened. So have you had those conversations with Brentwood?
It's something that we need to discuss with the county, but also there's very little that's taken place to the best of my knowledge at this moment.
Okay. Well, and maybe that's something we can draw out in later discussions. Because obviously we have discussions on matter 6 in relation to Dunton Hills. We've got discussions on spatial strategy, and then we've got other discussions in relation to infrastructure as well. So we can have those discussions later. But ultimately, you're not saying that, you're not necessarily alleging that there's a failure to meet the duty to cooperate. So it's more about the soundness impact of those discussions in relation to the strategy that's been developed. That's what I'm hearing from you. Is that correct?
I think that's correct. That's correct. So I would agree with that summary.
Okay. I'm going to come to Thurrock now before I come back to the council, and then obviously if anybody else wants to bring in their concerns on this particular area, I'm happy to take those discussions. So if anybody does have any elements, if you can put your hands up, but I will come to Thurrock first. So it's Mr. Hatter, isn't it?
That's correct.
Thank you, Mr. Hatter.
I think Thurrock's concerns go a bit deeper in that from our council's position, we don't feel there has been effective and ongoing engagement under the duty to cooperate on the Brentwood local plan. We accept that obviously as partners of a seller, we're looking at the wider strategic issues in the preparation of a longer term joint strategic plan, and both councils being parties to that. But particularly since the preferred allocations plan, there's been a kind of lack of proper and effective communication on the Brentwood local plan between Thurrock and Brentwood Council. This has particularly been on the issues to do with the spatial strategy and Dunton Hills Garden Village, but also in relation to general cross-boundary issues around transport and the lack of technical evidence. To use the transport as an example, I mean, Thurrock Council is aware through statements produced and topic papers produced by Brentwood Council that there is still work ongoing on the transport strategy, and in particular relevance to Dunton Hills Garden Village, and that particularly an update to the Transport Assessment 2020. Thurrock Council hasn't been party to any of that information. We're aware the County Council only received the latest information in early November. Thurrock isn't aware what the information is and the implications of that. And there is just a lack of communication and engagement across a range of issues that has been concerning to Thurrock. We've set out in our hearing statement that both ourselves, Essex County Council and Basildon Council did put a joint statement to Brentwood in 2018, particularly around Dunton Hills Garden Village, but also raising issues regarding the general spatial strategy. Now, we're also aware that Brentwood has continued individual discussions, particularly with Essex County Council as a highways authority, through its statement of common ground, may have resolved some of those issues between those two authorities. But Thurrock doesn't feel there's been effective engagement and communication, to pick up your point, on a number of its outstanding matters and how they've been taken forward prior to submission or even post-submission. And effectively, we've been asking for comments in relation to matters we've previously submitted, including post the Regulation 19 stage, and still not got a satisfactory response. Obviously, duty to cooperate can't be rectified post-submission. And so we've effectively got to a situation where there are a number of key issues. We never got satisfactory responses, or there's matters that are still outstanding in terms of technical evidence, and we're not aware of the full extent of that work. So we do feel that our concerns are more deep than just the fact that there's been a lack of clarification. There has actually been a lack of effective engagement and clear outcomes on a number of Thurrock's concerns.
Thank you, Mr. Hatter. If I can come to the council just for a response on that, and then I will go to the participants who've raised their hands. Is it Mr. Drain?
Thank you, Inspector. Clearly, as the position would state in terms of the hearing statements and the lack of statement of common ground, we're aware of the fact that we've not been able to progress agreement with Thurrock Council. I would suggest that engagement and effective engagement works both ways. And so there are examples whereby we've tried to engage with Thurrock through both of our plan making processes. and that has not been reciprocated in terms of the response and ongoing discussion with Thurrock in the way that we've been able to progress with other authorities. Ultimately, in terms of the ongoing issues, we're aware, and the reason we've indeed made sure that they are ongoing in terms of continued communication, we're aware that the objections to the spatial strategy that we're proposing stand from Thurrock, and therefore we've been trying to engage with them to best discuss those issues and work through what our disagreements are on them. The sort of the issue around ongoing, more informal communication is what I believe Ms. Hatt's is referring to in terms of the what he would say is a lack of response from us. We formally responded to the issues being raised in previous consultations by Thurrock Council for our sustainability appraisal, and we were very conscious to do that through the publication of that document in 2019. We have since continued discussion on the outstanding, or from what they would consider to be outstanding objections on representations, and indeed through this summer, very much noting that was post-submission, but trying to continue to talk about the issues that we have together. By producing a topic paper before the topic paper that was published in relation to Dunton Hills, to try and unpick a lot of the issues that are being raised and respond to that. So we've tried to effectively engage with Thurrock on an ongoing basis throughout the plan making process to this day. In terms of transport evidence issues being raised, as I said, we have been particularly conscious to try and resolve issues with Essex County Council as our highways authority. The published evidence, in terms of the transport evidence that is published, talks about the level of impact from a transport perspective of growth on Thurrock. That doesn't change. We've been looking to continue to work with County Council and Essex, Highways England on the transport evidence to get deeper into agreement on sort of methodology and the impacts in terms of mitigations that are coming out of that. And that's been an ongoing, very long, complex piece of work. But ultimately, the impacts as we see them on Thurrock do not change, and the engagement that we have with County Council as our highways authority for the area continues to think about the way in which those two highways authorities, Thurrock and Essex County Council, as they abut each other, engage with each other.
And can I just, before I just come to the other participants, can I just clarify about the statements of common ground? The revised framework came in February 2019. Which was prior to submission for examination. So can the council just explain why it didn't go down the route of producing statement of common ground, or was it in the process of producing them but couldn't get those produced in time? I'm just trying to understand why. I know it was a new requirement that sort of came in as part of the revised framework and what it states in the PPG. I just would like to understand why those statements of common ground hadn't been confirmed and submitted as part of the submission. So who will respond?
Yes, I'm happy to respond on that point. I think in reality, time constraints the sort of swiftness with which we were really told by MHCLG to prepare a local plan and submit that local plan as quickly as we possibly could. This council has always been very mindful of that, and so we've been working at speed. And so we recognise that there are some areas, I think, where for completeness sake and for ease of being able to read across the different representations, that would have been ideal to be able to provide all of those at the same time as submission. As I've said, I think in particular with Thurrock and Basildon councils through the Acela piece, there are ongoing conversations as well as with County Council, and so the statements of common ground have naturally been evolving over time in comparison to some other authorities where they were pretty much complete by that point. But we've over the period of the past couple of months leading up to these hearing sessions been able to formally sign those and get those published. with Basildon and Thurrock colleagues, given and County Council indeed, given the representations on these particular issues, they have been evolving conversations, and the swiftness of the programme has meant that we weren't able to do that at the same time as submission.
Okay, thank you. Can I bring in some of the participants, because I know some of you have had your hands up now. I've got, I know Mr. Banner, you did put your hands up first, so if I can come to you first, please. Oh, no, you've.
Yeah.
Yes, Mr. Banner. Yeah.
Thank you, Madam. I've got 3 points arising out of the discussion that's been heard so far. I'm not going to deal now with unmet housing need in the JSP, because I appreciate you deal with that later, though.
I really do appreciate that, yes.
It's obviously, as you said at the beginning, all these issues are interlinked in a way. It's quite hard to separate them out.
I'm trying to focus on the legal compliance of duty cooperation. Yeah,
thank you. Although that does have some legal consequences, we'll deal with that later. So point number one, there was a cross-cutting point, really. Mr. Drain made a comment, and I suggest quite a revealing one, early on in his discussion of this matter, where he said that the focus in relation to the duty to cooperate discussions was in relation to Dunton Hills Garden Village, because of its location near the borders. And that really does chime with what we say in our hearing statement on this issue at paragraph 2.7. Our hearing statement is document G1H. Paragraph 2.7, that yes, there have been cross-boundary discussions in relation to Dunton, but there really haven't been any meaningful discussions, and indeed very scant evidence at all of any real discussions in relation to the alternatives, including West Horton. And that's fundamentally deficient for two reasons. Firstly, you can't have an informed discussion about Dunton and its strategic consequences without having a consideration of the alternatives, because the two go hand in hand. The merits of the one fall to be considered, at least in part, by reference to the relative merits of alternatives. But secondly, it's unarguable to suggest that the alternatives themselves don't have potential strategic implications, leaving aside Dunton in relation to housing, infrastructure, etc. So the focus on one to the substantial or complete exclusion of the other, as reiterated by Mr. Drain, is itself of concern. Second point, and I'll deal with Basildon first, as they spoke first, Madam. Basildon's complaint, or Basildon's description of the process, both orally and at paragraph 1.2 and 1.3 of their hearing statement on this issue, referring, for example, to lack of transparency, their words, not mine, and insufficient information being provided and clarification, including, for example, the working on the evidence base, working on the emerging plan before the evidence was provided to Basildon. Irrespective of Basildon themselves now characterising that after the event as going to soundness rather than duty to cooperate, the question for the two of you inspectors, I suggest, is whether objectively, irrespective of the label Basildon put on it, objectively, is that something which indicates a failure to comply with the duty to cooperate? And I endorse what you said at the beginning, Madam. You said, has they really maximised the effectiveness of the plan? Well, how possibly can a situation where there was a lack of transparency, insufficient and inadequate information be given too late to one of the duty to cooperate authorities, irrespective of what that authority now says, how can that possibly maximise the effectiveness of the plan? And how can it possibly, to use Mr. Justice Dove's words in his description of the duty in his recent judgment, how can that have achieved effective, constructive and active engagement at the time when it was required? That's the very last two sentences of paragraph 56. At the time when it was required, effective, constructive and active engagement. So there may be all sorts of potential explanations, political and otherwise, why Basildon have decided not to allege overtly that the facts, as they describe, have given rise to the breach of the duty. But I suggest, very respectfully, what you and your fellow inspector have to do is take those facts and consider yourselves whether they are evidence of a failure to comply with the duty. And I say that they plainly are. In relation to Thurrock, I suggest, again, with the greatest respect, what appears to have happened is that an impasse has been judged to have been reached by at least Brentwood, and they've pushed on. And I suggest that that's very well evidenced by the point that we make in our hearing statement, that there were no bilateral discussions between Brentwood and Thurrock after Thurrock's objection until after the plan was submitted. Brentwood submitted the plan before having a bilateral discussion with Thurrock about Thurrock's objection. And of course, once the plan's been submitted, the horse is bolted as far as the duty is concerned. And I suggest that does indicate that what in reality has happened is Brentwood have proceeded on the basis that they're never going to get agreement with Thurrock, so they might as well crack on. And of course, the case law, for example, the case that we cited with the hyperlink in our hearing statement, is very clear. St Albans case, that the duty to cooperate applies even where there is fundamental disagreement, and that appears not to have been appreciated by Brentwood. So I do suggest that those three reasons, whatever the labels used retrospectively, demonstrate a fundamental and irretrievable failure to comply with the duty. I will also be saying in due course the unmet need issue goes to this and not just soundness. But I appreciate
unmet need a little bit shortly. I just want to try and I'll be moving on to that very, very shortly.
Absolutely, completely understand. So those are my points, Madam.
Thank you, Mr. Banner. I will just bring in Mr. Davey, because obviously Mr. Banner has talked about Basildon, and I want Basildon to talk about Basildon. Mr. Davey, do you want to just come back on that? Because obviously I've got somebody else in the room who's contradicting what you're saying. Well, not contradicting, I think that's the wrong word, but is highlighting the words that you've used in your statements and in your representations, but you've just told me earlier that you don't feel that there is a failure, that there's necessarily a failure to meet the duty, but that there has been some issues in relation to the evidence that's been available, etc. So could you just clarify that point, because there's a little bit of disparity there.
Yeah, I understand that. And in response to Mr. Banner's point, it really comes back to, as he said himself, the cross-cutting nature of the issues, really. Our concerns are that they are transgressing more towards soundness. And certainly one of the key points that Mr. Drain mentioned in his opening statement when he talked about looking to maximise sustainable transport access. It's unclear to us why they wouldn't have looked at an urban extension in Shenfield, given that Shenfield will be on the Crossrail route when that opens, as one such example, rather than a green belt site, which needs those connections being provided. But that's not a duty to cooperate matter itself. That's a soundness issue linked to the spatial strategy.
Do you see them more as a soundness issue rather than the legal compliance element from your perspective?
That's correct. Yes.
Thank you. Okay. Can I bring in some other participants who've been waiting very diligently and very patiently? Can I bring in the Essex County Council, please? Because I am aware that there has been this update to the local plan transport assessment that's only recently been done, and in your statement you made the comment that you weren't able to give a position on that because you hadn't had the opportunity to read it, etc. Now obviously I don't have a copy of that, and my other inspector doesn't have a copy of that, and it's not been provided to the examination. So could you just explain to us what you've been looking at in relation to that and what your position is on that update, please? Is that Mr. Robinson who's going to be talking on that?
Yes, thank you, inspectors.
Thank you.
We have, just to say, on the duty to cooperate, we have been meeting regularly with Brentwood, discussing the transport evidence base. But as outlined in our hearing statement, we did ask for some further information to be provided when the plan was submitted, and some of that has been provided in the latest update that we received at the start of November. But our initial review suggests there's still further information that we would require to enable us to make a clear decision on whether we're happy with that transport evidence.
So there's still some gaps in the evidence, that's what you're saying?
Right, yeah.
Okay.
So, I mean, I wasn't proposing to go into detail at this stage. It might be more for the transport session.
I agree.
And we may have resolved some of those gaps.
Okay, thank you. Can I just clarify when that the updated transport assessment will be made available? Is that a response to the council?
Thank you, Inspector. We have a particular issue at the moment, which we will bring to your attention separately in terms of the Lower Thames Crossing development consent order application process, which was many will be aware was withdrawn, which now means that we just need to work through with the Lower Thames Crossing team the extent to which information that we have used on traffic flows from the Lower Thames Crossing model can be in the public domain that is used within the transport assessment. So there is some checking that needs to go on to just make sure that we're able to publish that work and not be in a bad position in terms of the non-disclosure agreement that we have with Lower Thames Crossing, as many other authorities do with that information. Our previous position had been hoping that with that DCO process in the public domain by this point, as was hoped, that issue would not be there at all, in the sense that that information would then be in the public domain, and so we would be able to publish our transport assessment accordingly. So we are needing to look at that, but as Mr. Robinson stated, we've been working continually over the past year with County Council and Highways England colleagues on resolving some of the questions and issues that have been raised in respect of the transport assessment that we've published. So we are keen to make sure that we can publish that as soon as possible, as well as continue to work with the County Council on the things that Mr. Robinson set out there.
So there is no timescale at the moment as to when that document could be made available, or whether it could be made available at all.
Thank you, Inspector. Sorry, at the moment, I don't know when it can be made public, but we're working to make sure that it will be as soon as possible.
Okay, thank you. Obviously, because we do have the elements of infrastructure going to be discussed tomorrow, elements are going to be discussed throughout the hearing sessions, because it is quite a critical point. And obviously, we do have a particular session on infrastructure and transport infrastructure in February, so I'm hoping by then it should certainly be available by that point. Okay, thank you for that. Mr. Robinson, was there anything further you wanted to say on duty to cooperate before I move on to some other participants?
I don't think so in terms of duty to cooperate. Just when you mention infrastructure, obviously the transport assessment will inform infrastructure requirements for the plan as well, and equally the infrastructure delivery plan will then confirm the suitability of the transport assessment. So it's all interrelated, unfortunately.
It's very all interrelated, yes. Which is why we need to see those documents as soon as possible, obviously. Is the document significantly different to the existing transport assessment?
In terms of outputs, I don't think it's significantly different, but there are some infrastructure elements that are still being worked on.
Okay.
So we can't yet determine if they're acceptable or not.
Thank you.
And that will take some time to review as well. So again, we're probably looking at the February sessions before we can comment fully.
But you hope that you should be able to comment by then?
That's the hope, yes.
Okay, thank you. Okay, can I bring Mr. Hill in, please? So you're representing Hallam Land Management. Mr. Hill, you've been very patiently, so thank you very much for that.
Not at all. Thank you, ma'am. I'm not going to take a great deal of time now. I will associate myself with the representations that have been made to you by Mr. Banner without repeating them. At this stage in the session, you're looking, of course, at the question of whether the council has carried out effective engagement in relation to all relevant strategic matters. Ma'am, you summarised what you're looking into here is whether the council's maximised the effectiveness of the plan. Now, I fully appreciate that there's sometimes a fine line to draw between what's a DTC issue and what's a soundness issue. But I would say that as a good guide or indicator as to whether that effective engagement has taken place in relation to all relevant strategic matters, as a good guide or indicator is what remains unresolved. And it seems to us, certainly, that in terms of strategic housing and transportation issues, a great deal remains unresolved. Now, we're going to come and look at some of those matters later on, and I'm not going to trespass into those later sessions. But the scale of what remains unresolved must, it seems to us, call into question whether there has been effective engagement in relation to all relevant strategic matters. So I'll leave that point there for the time being, but obviously come back to it in the context of unmet need and the JSP in due course.
Thank you. Thank you, Mr. Hill. Can I come to the council for response on that particular point, please? Mr. Drain.
Thank you, Inspector. Do you mean the point that's just been made, or generally that some of the? I've got some responses to generally some of the comments. I want to do
generally because we are coming up to 11 o'clock. So after this session, we are going to have a break, and then we'll be coming back and talking about unmet needs and how that's been dealt with through Duty to Cooperate. Yeah.
Thank you. I mean, I would just come back in terms of the recent comment made to say that there are disagreements about spatial strategy in terms of where growth should go. There are issues that clearly will be impacts from development, regardless of where the locations are, that we are working with our partners on, and many of those have been resolved. So I think you can see progress in terms of what we have been able to resolve. The bigger issues are much wider than Brentwood Borough, and that is why sometimes those things are difficult to fully resolve in terms of agreement, but that doesn't mean that there hasn't been effective engagement on those things. In terms of some of the points made earlier on alternative sites, I think the degree to which we've assessed alternative sites and engaged with our neighbours and others on these issues is clear. It's set out through the sustainability appraisal process. And that sustainability appraisal process, as I mentioned earlier, included the adjoining local authorities' comments when there were questions about the way in which we'd gone about selecting sites and assessing alternatives. And just coming back to that point generally on disagreement, it's continual disagreement that we've had around where we should grow, particularly with Thurrock Council. But that engagement has continued through the Acela process in terms of that wider piece. So that probably comes back to what I was just saying a moment ago. There was a comment earlier, I know that it's not relevant here, but there was a comment earlier about urban extension in Shenfield. I would just say we have an urban extension in Shenfield. It is for north of 800 homes at land north of Shenfield. So in that sense, I think that answers that comment.
And just a response to Mr. Hill's point about the scale of unresolved matters, strategic matters. Anything further to add on that?
No, I think they remain disagreements about location of growth. The impacts of growth are being worked through in the evidence and the engagement that we're having with authorities.
Thank you. Does anybody have anything further that they want to ask in relation to question 1? It's A to D that I've been looking at in particular, although focusing on the constructive engagement element. When we come back after the break, I would like to move on to part E of the question, which is about unmet needs and how that's been taken into account as part of Duty to Cooperate. And then obviously, and then finalising on overall about Duty to Cooperate. So anything further on that point? No. Well, I think at this time it's almost 5 to 11, so I would like to take a 30-minute break. Gives everybody a bit of a screen break from the screen. If everybody can be back, please, at 25. Oh, there is a hand up. I do apologise. It's sorry, the name's wrong. I'm trying to remember who that is. I know it's not Charlotte.
Charlotte Mark. Ian Jimby. Acting for 6G.
Sorry, yes. I'm going to put a note that you are actually Charlotte on my notes. I'll remember. That's right.
I've had worse in notes of appearances before. So. So I just wanted to make a very brief point because I know you want to break, Ma'am, but I just wanted to emphasise the point really that we are dealing here, or that rather the council is dealing here with a process point, a legal process point, and the duty to cooperate. And I think the context is important because even Thurrock, who maintains an in-principle objection to the spatial strategy adopted by the council, are only really raising a complaint from the, I think, preferred options stage. So the last 2 years, they are making a complaint about lack of effective engagement. And I think you need to have in mind that there were previous statements of common ground entered into September 2017 between the Association of Authorities, signing off that the duty has been complied with in respect of all strategic transport matters. There's a further statement of common ground entered into in the middle of 2018. And I think here it's important to understand the point that Mr. Drains made about the collaboration between the South Essex local authorities, SELA, and it's quite, I think, artificial to divorce that ongoing collaboration from this process, because it's perfectly clear that the statement of common ground entered into in 2018 specifically identified the individual local plans being promoted by the constituent members and endorsed that, and was cognizant that they were at different stages. It's also clear that at these meetings that the association have met regularly, there's an update on each of those local plans. So it's quite clear that some of the issues you're addressing here have been raised as part of that ongoing process. And I do think it bears upon the effectiveness of the discussion that has been held both by Brentwood and its neighbours. So I think it's just a contextual point, really, that it's not just looking at this local plan in isolation. I do think you need to look at the context in which the plan and Brentwood's engagement in its duty has also played into the wider discussions with the SELA. Thank you.
Thank you, Mr. Hill. Council, Mr. Drain, do you want to add anything to what Mr. Hill, or respond to any points that Mr. Hill has raised? Sorry, Mr. Ginby has raised.
Thank you, Inspector. And no, thank you. No further comments.
Okay, lovely. Thank you. I think on that note, as I've just got names wrong, we do need a break. So so thank you very much. If everybody can be back for, well, it's almost, if everybody can be back for 11:30, please. Don't leave the session. The session is still going to run, but please ensure that cameras and your microphones are off, although I believe that Annette has the power to turn everybody off anyway. So I will see you again at 11:30. Thank you. Welcome back, ladies and gentlemen. Have we got everybody back? Yes. Excellent. Thank you very much. Now, my apologies, Mr. Banner. You did have your hand up before, and I surreptitiously ended. I was so desperate to get a coffee that I missed you out, Mr. Banner. So please make your comments now.
Thank you, Madam. Don't worry, I got myself 2 coffees, so I share the sentiment. Madam, I just wanted to come back very, very briefly to what Mr. Jinby was saying right at the end, when he was relying upon some of the earlier discussions, etc., way before the sort of Regulation 19 at this stage. And I just wanted to really remind you in that context of what we say and ask you to reconsider in this context. Paragraphs 2.5 and 2.6 of our hearing statement, really drawing from what Thurrock have said, that there was a really big problem with the earlier discussions because at that earlier stage, Dunton Hills had already been started to progress before the outcome of what was meant to be the joined up process of working out the strategic growth locations through this study, the report of which we may see shortly. And effectively through that early jumping of the gun in relation to Dunton, the council skewed the process and the engagement in favour of its what's turned out to be its preferred option. So those earlier discussions, I suggest, if anything, if that's what's being relied upon now, exacerbate the concerns rather than cure them in any way. So I just wanted to remind you of that in that context.
Thank you. Mr. Ginby, do you want to respond back on that, as Mr. Banner was referring to your particular points that you've raised?
I apologise. I swapped laptops. I was to engage with my team, but I can't get my video to work.
That's okay. We can hear you.
Great. Thank you very much. No, not much of substance to add. Say the point I was simply making was a procedural point, and to emphasise the point, as I know you are aware, Mum, that you're dealing with these duties of process. So I was to make a point that there has been collaborative engagement between this set of authorities for quite some time now, and I didn't really want to leave the point on.
Oh, I think we may have lost Mr. Ginby. Yes, I think we have, unfortunately, that connection. Okay, well, if Mr. Ginby can get back on, then obviously I'll ask him again for any further response. But from what he was saying, it seemed to be on the procedural point of when statements of common ground have been produced, and that they have previously. But obviously, I will take on board those comments that have been made. Thank you very much for that. Now, I'm just going to double check there's no other hands up. No. Okay, right. Okay, can we move on to the question about unmet needs? Please. Now, the council, in your hearing statement in response to this particular question, you say that you say no. So is that saying that no, there are no unmet needs, or no, there isn't an agreed protocol for dealing with unmet needs? Or could the council just clarify your response? And then you do refer to an early review of the plan. We'll review that issue. So can you just clarify what your response of no means in relation to question part E of that first question, please? Is that going to be?
Yeah, Mum, can you hear me?
I can, yes. Is that Mr.
Shadowrevian? Yeah, I'm so sorry. Actually, I'm having difficulties on occasions, and I can't find the place where I put my hand up either. It seems to have disappeared. But nonetheless, no.
If in doubt, if you can put your camera on and wave at me, somebody will let me know.
Okay, thank you very much.
That you want to speak.
Thank you very much. Thank you. No is a reference to the fact that we are meeting our objectively assessed need. That's what it means.
Ah, but including those from any neighbouring authorities. My understanding, and I think the council accepts this in somewhat different.
Yeah, no. We are meeting our own needs, and we're not attempting to meet any adjoining authorities' needs.
Right. Okay. Thank you for that clarification.
It's all right.
Okay. So, following on, Mr. Banner.
Well, if it's a convenient moment, I mean, I've got a few things to say on this issue, but I don't want to intervene if you're going to ask somebody else first.
No, that's fine. No, if you want to come in now. I suppose I just wanted to clarify that my point is about, or what I would like to understand is there is that the council accepts in other statements that there are unmet needs in neighbouring authorities, and that is specified, but that the issue should be reviewed or discussed as part of an early review of a plan.
Yes.
Of the plan. And so I want to understand that. I don't necessarily want to go into the unmet needs issue in terms of soundness, because that's a different issue,
yes.
But in relation to the implications for the duty to cooperate, meeting that duty, that's what I'd like to try and focus on. So, Mr. Banner.
Yeah, no, completely understand that, madam. And it is a duty to cooperate issue. I mean, there are also soundness aspects to it. It's a duty to cooperate issue because plainly it raises cross-boundary issues, and it appears to be fairly clear that the council's position is it's refusing and has refused to countenance meeting unmet need from other authorities because of its approach that this plan will meet the council's own needs, and the subsequent joint strategic plan process will deal with the issue on a joined up basis, issue of unmet needs subsequently. So there's an acknowledgement that there is a cross-boundary issue, but an approach of not dealing it through this plan, but dealing it through the later plan. And that is fundamentally legally flawed. I don't want to repeat what we said in our matter statement, because you'll have read it and you appreciate it. Can I just, however, for the record, endorse what Hallam say on that, paragraphs 1.4 to 1.7 of there. I mean, just to elaborate a little on the points made there. I mean, firstly, the PPG is very clear at 61-022. The passage relied upon by the House Builders Federation, who I also endorse in relation to this, that you can't just defer the duty to cooperate. It's a duty that applies to this plan. And therefore, you can't rely upon a subsequent plan as somehow discharging the duty that applies to this plan. The points that we set out at 2.12 of our matter statement go to this issue of the duty and not issue of soundness, and just kind of elaborating on them. Firstly, you can't, even if it was possible in principle in some way to rely upon a future subsequent plan as being able to deal with issues that engage the duty without this plan attempting to engage with them in the context of duty to cooperate. Even if it was in principle possible, there's no guarantee in this context that the JSP will be adopted, and if it is adopted, when it will be adopted, and as Hallam say, whether it will in fact deal adequately with the issue of cross-boundary needs. There's a lot of uncertainty in the timetable. It's already been punted back a few times. The example, as we set out in paragraph Roman numeral 2 of 2.12, the example of the GESP, the Greater Exeter Strategic Plan, and the West of England Strategic Plan are very clear indicators of the challenge. I mean, all the issues that have caused the duty to cooperate challenges, if I can call them that in that neutral term, in relation to this plan, they're all going to raise their head again in the context of the JSP, and it only takes one authority to pull out saying we're not going to promote this plan, and then we're stuck with a plan that only meets its own needs and doesn't even try to consider trying meeting joined up needs. So there's a complete lack of certainty, and I suggest you can't have any confidence in that process. And then on top of that, you've got the planning white paper, which may render the whole process even more uncertain and academic, because the duty to cooperate may not even apply subsequently. That doesn't exonerate this plan, but it may very well mean JSP isn't subject to that duty, or indeed can't happen because things are done differently in the future world. So there's a even more exacerbated uncertainty because of that. And then the final point is, of course, that as we understand it, and again, I think our understanding is the same as Hallam's and the House Builders Federation on this point. As we understand it, the JSP isn't going to itself make allocations or greenbelt removals. All it's going to do is do what should have been done before this plan, which is work out who should bear what proportion of the unmet needs on a joined up basis, and then there'll be a future plan. So it's not even going to be on its own terms a panacea. It's going to start the whole process that should have started before this plan, not afterwards. So for those reasons, as set out in writing in our statement, we say that the council's approach, which is to refuse to consider it, it's not a question of thinking about it, engaging with it, and then making a decision, which may then have more of a soundness issue. It's refusing to engage at all in this issue because of the subsequent JSP. It is a fundamental duty to cooperate failure. And now say I won't mention the numbers. Oh, and the one last point, sorry, madam, I do apologise. A further point that's relevant in this context is the immediate nature of the unmet. This is not a case where one is looking about future needs that aren't being planned for and then will become unmet needs, because the plan periods of the relevant authorities, which we set out in our hearing statement, we're already well into them. So the unmet needs that have arisen are in some instances, more than half a decade old because of the plan periods. So they are in very considerable part existing needs that are there now and have that urgency. So the idea is that you kick the can down the road of JSP, which itself kicks the can further down the road if it ever happens, or whatever happens with the subsequent plans. Well, all that time, that existing unmet needs getting bigger and bigger and bigger and bigger, and there are real people needing real homes who are not having their needs met. And so we do invite you to take the right decision in this respect, having regard to those people, because it is, it's real people's housing needs we're talking about here, not just everybody's clients' interests.
Thank you, Mr. Banner. I've got a number of hands up. I would like to bring in, I'm sorry, I don't know exactly who has put their hand up first, but I would like to bring in Mr. Barent, please, first, from the Home Builders Federation.
Thank you, Mark.
Have I pronounced your name right, Mr. Barent?
Mr. Barent, Mark. So yes, you did get it right. It is the bane of my life in these things, as people with all equally silly names will probably attest to as well. But with regard to our points, I think Mr. Banner has really covered many of them and referenced our statements as well, really, with regard to that. I think our concern is really about in terms of the effectiveness of the engagement and how that has then informed plan preparation. How has it then fed back into how the plan has been prepared? And I think this is the difficulty. It hasn't really gone back into that plan preparation to consider. It feels like Brentwood has considered itself an island and then hasn't need to grapple fundamentally with the problems that have been raised as part of the duty to cooperate. So I think I really would agree with what Mr. Banner has said. The other issue I would like to raise is with regard to the importance of a continued understanding of the issues with regard to cooperation and strategic issues. And I would come back to the issue of London, really, with regard to the unmet needs of London and what is a growing issue of unmet needs. And we state in our statements about the London plan and the outcomes of the hearings of the London plan, which were published in October 2019 with the panel's report, which shows that there's significant increase in the level of unmet needs within the capital. Which haven't been recognised within document F5D in terms of the scale of the issue that you're to consider, whether it's now in terms of the duty to cooperate, but in future sessions with regard to unmet needs and the housing requirement. So I think those are the key issues that just haven't been addressed by the council. There seems to have been a number of outputs in terms of a unmet needs protocol, but there's not many outcomes in terms of what is actually going to be delivered on the ground to address these unmet needs that, as Mr. Banner says, are now. They're not in the future, they're here now and need to be addressed. So that's all I want to say, Mark. Thank you.
Thank you. I will now take comments from Mr. Hill, and then I will be coming to the council for a response. So Mr. Hill, please.
Thank you, ma'am. And just to avoid any confusion, you're dealing here, of course, with sub-question E, and that is asking about unmet needs from any neighbouring authorities as well, of course, as Brentwood's own needs. Some of our answer in relation to this is actually set out in our hearing statement under subheading B. So I hope you'll read back to that and take that into account when you are considering what we say rather shortly under the subheading for question E. But we here have in mind very much the Basildon unmet need as declared of 4,000 units, and the fact that this is not addressed and certainly not resolved in any way as part of the processes that have led to the submission of the plan that you're now examining. There is the sticking plaster advanced of the joint strategic plan, an idea which, as we understand it, dates back to 2017. So far as we are aware, very little progress has been made in relation to this exercise, and there is no clarity as to whether this plan would actually have the ability to allocate land for development as between the member authorities. The likelihood is, as we see it, that this will simply be a prelude to reviews of all the plans of the constituent member authorities, with all the time and delay that that inevitably involves. So the time scale, as we see it, for addressing this declared unmet need of a neighbouring authority is going to be very protracted indeed. However, it is likely that Brentwood is going to play some sort of a role, or should be playing some sort of a role, in the resolution of that issue. It's my point number one. Point number two, which really flows from it and is really putting down a marker for later, ma'am, we say at the very least that this means that it's all the more critical that Brentwood's own needs are met for an appropriate plan period. We're going to be coming to looking at those matters in other sessions this week. And third and last, and in this context, I just want to put down another marker for later. I think it's important to do so. This examination needs to be aware from the outset that the expected delivery for Dunton Hills, the Garden Village proposal, which is the most significant in the plan, is, according to the statement of common ground between the council and CG issued, I think, last week, it's going to fall by over 800 dwellings from the previously expected delivery in the plan period. So there's a further strategic scale hole in the supply, which can't be ignored and needs, I think, to inform, ma'am, your consideration and your colleagues' consideration during these early sessions of the examination. Thank you.
Thank you. Okay, I've got a hand up from Mr. Davey. Is it on this, still on this particular point?
Yes, it is.
Then,
yeah, yes, it is. It's just in relation to the comment.
Your comments then, and then I'll go back. I'll go to the council.
Yeah, it's just in relation to the comment that Mr. Hill made there about unmet needs from Basildon. I would advise that we have identified an additional capacity in our town centre. So with the regeneration that's taking place there, we will be meeting our overall objectively assessed need. So we don't.
I understand you're currently at examination.
That's correct.
What progress has been made on that examination?
Well, the hearings are still yet to take place, but we submitted the plan in March 2019, but then we received a a direction from DEFRA to improve air quality.
Yeah.
So the hearings were placed into suspense. Yeah. We have subsequently resolved that, but we are anticipating receiving our MIQs at some point this month. We've had communication from our programme officer on that.
I've only asked that question to understand how far, whether the objectively assessed need has been examined and whether then the supply has been examined. So it's how far that's gone in relation to that. But I take your point that from your perspective, you now consider that you will meet your objectively assessed need, but that hasn't been examined yet.
Not as yet, no, but we are receiving the planning applications now for the town centre. So with that in mind, we wouldn't anticipate that there will be need that Brentwood would then need to meet.
Thank you, Mr. Davey, for that update. Appreciate that. Thank you.
Thank you.
Can I come to the council then for a response? I know there's quite a few comments that have been made. Mr. Shadorevian, please.
Thank you very much, Ma'am. I was pleased to hear that bit of news just now, not because it helps us, but because it helps Basildon. And let's not forget, actually, it's this plan that is the subject of this examination. And Ma'am, if I can just remind you that we did consider high growth options at Regulation 18 stage. When we got to Regulation 19 stage, it was confirmed and had already been confirmed through Basildon's own plan process and its Regulation 19 stage that they did not require adjoining authorities to meet any of its then acknowledged unmet need, and that it would do so through the JSP. And that actually was a sensible approach, simply because part of the problem for Basildon was a structural one. It's not that it couldn't identify sufficient land to allocate. It's the means by which houses would be built and delivered that was an issue for Basildon. There are structural issues that need to be addressed, including transportation issues, in order to create the circumstances to engage faster delivery. That is why those issues, those structural issues, were seen to be best addressed on a sub-regional basis. And the idea that those structural deficiencies could be resolved by the release of additional land in a neighbouring borough is simply preposterous. You'd simply be transferring a structural issue into an adjoining authority. And that is why it needs to be considered on a sub-regional basis, insofar as it may remain a problem. It may not now, from what we've heard. And if that is the case, all well and good. If there is an issue that needs to be determined on a sub-regional basis, certainly this plan and what is proposed in this plan doesn't prevent or obviate a successful outcome in that respect. And even if Mr. Banner is right and the duty to cooperate ceases at the time when the JSP comes about, of course it makes no difference at all, because it is a plan which involves and engages all South Essex authorities, and so the approach will be a joint one. I think, Madam, that's all I need to say in response so far.
Thank you. Thank you, Mr. Shadorevian. Anything further from the council on the comments that have been made? And then I will go back to the hands that are up. Nothing further on those points. Okay. Mr. Banner, please.
Thank you, Madam. Just 2 points responding to what Mr. Shadorevian has just said. The first point, he relied upon the early consideration of higher uplifted figures, albeit in the context of a different understanding of housing requirement. But the critical point, Madam, is that was abandoned because for the reason set out in the original sustainability appraisal. So this is the essay of January 2019, which makes very clear that a approach which would seek to meet unmet needs from neighbouring authorities was not considered to be a reasonable alternative because of the JSP. It's the second paragraph of box 5.2 on page 13. So at a time when the duty was still engaged, the consideration was overtly abandoned for that reason, namely the JSP. And the second point was the idea, well, does this need to be dealt with on a sub-regional basis? Well, there's a need to deal with an issue on a sub-regional basis doesn't require waiting until a sub-regional joint plan. I mean, one only needs to look, for example, at the succession of authorities that adopted their individual plans in and around Oxford, where there's an agreement, a memorandum of understanding as to what proportion of Oxford's unmet needs each authority ought to seek to plan for. And then there were a series of authorities that sought to do that in accordance with the joint MOU. So the idea that the sub-regional nature of the problem necessitated a unilateral standalone plan which kicked the can down the road to a later joint structure plan, joint strategic plan, and no pun intended. The idea that the approach the council has done was necessitated by the nature of the problem is simply not right and not borne out by recent examples such as Oxfordshire.
Thank you. Thank you, Mr. Banner. Council, would you like to respond?
I don't have anything really to add. Other than that, Mr. Banner's observations are really criticisms in abstract. They don't dwell down to the particular issues he says ought to have been addressed, these structural issues, and they're matters that need to be investigated on a joint basis.
Can I just clarify, just to make sure I've got this correct, just from the council's perspective? At the time of producing the particularly the Reg 19 stage of the plan, were there at that time unmet needs? There weren't any from yourself, were there? From Brentwood's point of view?
No,
that's my understanding. Were there any? Was there any other local neighbouring authority or any local area actually asking Brentwood to meet unmet needs or consider unmet needs? Can I just clarify that point so I'm very clear on that? Is that going to be Mr. Shadarevian? Oh.
No, Inspector, I think that's me. Thank you.
Mr. Drain.
No, there were no formal requests from adjoining authorities at that point to meet unmet needs. I think, as the point's been made, we tested things, but there was no formal request at the point of the Regulation 19 stage to meet unmet needs from elsewhere.
Okay, thank you. Does anybody else have any comments that they wish to make on unmet needs? Mr. Banner, please.
I'm so sorry to put my hand up again, Madam. Just on that last point, I mean, as you'll doubtless grasp already, that whether or not there was a formal request is relevant, but plainly can't be determinative. The current position with Basildon, of course, has developed post-submission. The position at the time is set out in the essay in the same box that I gave you the reference to in relation to Basildon, and there's also an unmet need from Havering as set out in our hearing statement.
Thank you. Okay, thank you. Okay, Mr. Hill, please.
Just to confirm, ma'am, that's also our understanding that at the time of Regulation 19, there were identified unmet needs in neighbouring authorities.
So was that, can you confirm which authorities that was?
Certainly the Basildon position was one of unmet need.
Havering's been mentioned.
Havering was also mentioned. Yes.
Okay. So I will just bring in my other inspector. So, Mr. Warden, you've got your hand up. You're allowed to speak.
Thank you. Could I just ask about a question really for Mr. Hill and Mr. Banner in relation to that last point that particularly Mr. Hill has mentioned? How was that articulated in terms of those unmet needs at the time? How was it articulated by those authorities?
So I think the best thing for us to do is to refer you back to the documents, which I'm very happy to do, perhaps during the short adjournment.
Yes, ditto. I was just looking for the reference, so we can do that. The reference in our hearing statement to Havering's position is the final bullet of 2.15. But we'll see if there's any further articulation, an earlier articulation prior to that.
Would you like a short adjournment just to check documents, or are you happy to just do it whilst?
I'm in your hands. What you would find most convenient. I mean, I'm happy to crack on and let you know the reference, if there is a reference to anything before you, as we go along.
Mr. Warden, have you got anything further on that particular point?
Just in terms of, in addition to the points you've made in your statements, is there any other evidence that you could point to that suggests that is it that those authorities were making some comments through various communication channels that there was unmet need that needed to be met at that particular time?
I mean, to be sorry, so I'm jumping in without putting my hand up. But I, with great respect, I'd say actually the question really ought to be framed the other way around, because it's for the council to satisfy the duty to cooperate, not for us to show that they haven't. And of course, the critical point is that if the issue of unmet needs across the sub-region had been dealt with on the joined up basis, then those issues would have been dealt with before this plan was submitted. So what's happened is effectively this particular authority has pushed ahead with its plan without these issues having been resolved. So I wouldn't quite say it's for us to point to a specific request from another authority. What's critical is that, for example, Havering now in its main modifications recognises that there was significant unmet need, as set out in that final bullet of the paragraph of our hearing statement I mentioned a moment ago, and the ability of this plan to consider dealing with this unmet need is constrained by the fact that there wasn't that engagement by Brentwood before this plan was submitted, because Brentwood refused to countenance considering the issue of unmet needs from wherever they came at the critical time, for the reasons set out in the SA. So just simply ducked the issue altogether. So I would urge you against thinking, well, is there a piece of paper, a smoking gun, saying please deal with these unmet needs? The prism through which to look at this, or the end of the telescope, is, are there authorities with unmet needs, and has adequate engagement been undertaken with those authorities as of the submission of this plan? Answer no, because the issue of dealing with unmet needs at the final stage was considered to be not for this plan altogether, and therefore, and if it hadn't been considered not for this plan, and if there had been proper consideration of it, then the issue that subsequently arose in relation to Havering may well have been dealt with at the time. And instead what you have is this ad hoc piecemeal approach, during which time all the unmet needs accumulate and get worse and worse. But there may well be something prior to the 2020 main modification Havering before you. We'll double check. I can't tell you off the top of my head, but I do say it doesn't really matter because it's not quite the issue.
Thank you.
So I wonder.
Sorry, so there's several hands up at the moment. Can we come to Mr. Shadorevian, and then we'll come to you, Mr. Hill, and then I know we've got Mr. Burrington on there. Mr. Shadorevian.
The points you were making was a simple one. What we're going to do is examine the Regulation 18 responses to see if there was anything there which ought to be brought to your attention. But I'm not going to rehearse the arguments again, and I feel that Mr. Banner unfairly portrays the situation. I just want to bring in Mr. Drain briefly on a couple of points, if it's convenient for you, Madam.
Yes, we can do that now. That would be
yes. All right.
Would be
Thank
helpful.
you.
Thank you, Mr. Drain.
Thank you, Inspector. I think, as we've been speaking about before, there's been continued engagement with authorities, including on this issue of unmet need. So at the point of preparation of the local plan, it was agreed with different authorities in terms of unmet need that there were none that Brentwood was to be meeting. But I would just point everyone in terms of what our hearing statement sets out in the direction of the EPOA unmet need protocol for Essex, the Essex Planning Officers Association document, whereby Essex authorities have signed up to a protocol, a system by which unmet needs can be put into that, and we go through a sort of flow chart of how we would need to deal with those, and that has not happened because there are not official requests to meet unmet need in this situation that Brentwood is trying to deal with.
Thank you, Mr. Drain. Can I ask Mr. Hill to come in and on the discussion?
Yes, as I said, we'll check the references, but so far as I am aware, the Basildon Regulation 19 plan says itself in terms that it will have 4,000 units unmet in terms of the needs that it's able to satisfy. So I think that must be the source of the material that I was referring to earlier. But we'll check that and make sure that you have a full list of the appropriate references.
And can you, it would be useful, and I know we've got Basildon here, so they may be able to respond, is to clarify when that was made public. So when that was in the public domain, that knowledge of potential unmet needs. So Mr. Davey, are you able to respond on that point at all?
Yes, so that is correct. The figure was 15,465 homes against an overall identified range of between 19,440 and 19,720. And those figures did appear in the Regulation 19 consultation version, which was then submitted in March 2019.
So when was it consulted and when was it made public? Can you remember?
So that was
2018, I think.
Yeah, it was during 2018. I can't remember the exact date, but yes, those figures are in the public domain. But we are again as a consequence of the publication of the MPPF in 2019, and then obviously the general malaise on affecting the high street now. We have identified a range of town centre projects, and that has also then helped to identify additional sources of capacity over and above that which was included within the submitted plan.
Yeah. So from what you said before, you're saying that your position has now changed in relation to that unmet need, because you are now saying that
is correct.
You don't see that there is an unmet need, but obviously that hasn't been tested at examination yet.
No.
But that's your position.
The position is correct, and it hasn't been tested at this point.
Thank you, Mr. Davey. Okay. Mr. Hill, anything further you wanted to add? You still got your.
I did think so, ma'am. Thank you very much indeed. I think the point I've made is a sound one. That the plan, as submitted by Basildon Council, did disclose 4,000 units of unmet need. Yes, there's some initiative underway to seek to address that. Whether it does address it is all, it seems to me, for another day. But the simple numerical proposition that the submission plan falls short of meeting the Basildon needs by 4,000 units is a correct one.
Okay, thank you. Okay, I've got a few hands up now. Can I come to... I'm just going to go down the list that I've got. So my apologies if it's not quite in the order that everybody put their hands up. Mr. Gimby, please.
Thank you, ma'am. I just wanted to respond briefly to your fellow inspector's question, which I think is, I disagree with Mr. Banner, because I think it's a perfectly fair question to raise, which is how was this alleged unmet need articulated to Brentwood? And you've received a clear answer from Mr. Drain that there was no request from any neighbouring authority for Brentwood to meet its unmet need. Mr. Banner refers to paragraph 2.15 of his client's statement, which seems to me to be their assessment of unmet need. And it's unclear to me whether and the extent to which that paragraph includes information which is pre or post submission of this plan. And you also have before you statements of common ground now with, and you've heard from Basildon this morning, that there's no unmet need in either Basildon or Havering. So I hear what Mr. Banner says, but you've had a clear answer from Brentwood on this. There was no request from any neighbouring authority to meet unmet need at the time of submission. And bearing in mind we're dealing at the moment with the process of duty to cooperate as opposed to soundness, I think that is a perfectly legitimate response.
Thank you. And let me just double check. I think it's just Mr. Banner's hands up now. Mr. Banner, please.
Thank you, Madam. Just on that, in relation to the position said now to be the case in Basildon, as you said, Madam, it's still to be tested. I would urge you to exercise a degree of caution about that untested position in light of what you've heard, that it's town centre, for example, vacant properties in the high street, etc., that have informed the decision that there is now that capacity, because those kinds of units, I think you can take notice of, tend to be more challenging to deliver family units and tend to be more challenging to deliver affordable housing. And so the implications of that nature of the newly found capacity, as it's said to be, for the full range of housing to be made, may very well need to be tested very carefully. So I take it with a pinch of salt. This is where Mr. Justice does comments about after the event, statements of common ground and agreed positions during the course of the examination must be treated with a heavy pinch of salt, given the time at which the duty to cooperate has to be complied with. I've given you the paragraph references already, and you're familiar with the judgment. And finally, Mr. Jimby, the one reference he didn't come back to that I did give you, but for the audience, that's page 13 of the first of the two essays, which sets out very clearly the position in relation to Basildon. I haven't read it out, but because it's the council's own words, but you will have read it and doubtless will reread it. The issue of meeting unmet needs through the duty to cooperate was on the council's own case, unquestionably engaged, and the council's answer was leave it to the JSP.
Thank you, Mr. Banner. Mr. Shadorevian or the council, any response to that, or shall we move on?
I think we've already set out our case on that. Though much though I'm tempted to respond again to Mr. Banner, I don't think it's going to assist you, Mark.
Thank you. Mr. Warden, anything further on that point that you raised?
No, thank you, Mrs. Wright. Thank you.
Thank you. Okay. Oh, Mr. Davey, please.
Yeah, just to respond to Mr. Banner's last point, while of course the extra capacity hasn't been tested, you're quite right to make a note of that. We are getting the planning applications coming through now. We've had an application for 2,800 units in Eastgate, which is one of the key sites. We've got another one for 500 coming through, and again the viability work that we've done shows the schemes are viable. So there's no reason to really doubt that we can't deliver our full OAN based on what's happening so far.
Thank you for that update, Mr. Davey. Thank you. Okay, I'd like to move on from obviously unmet needs in relation to Due to Cooperate. I know we have sort of moved into soundness sort of issues there as well, but that was invariably going to happen. We're coming near to the end of this first session now. And the final question is that's in our MIQs is about the robustness of the evidence to support the cooperation activities. Now, I'm not proposing to go through that. I think we've had that discussion already this morning as part of the other overall focused discussions that we've had. What I would like to do is just give anybody the opportunity to have a final say on Due to Cooperate, if anybody has it. And then I've just got a couple of pointers in relation to some of the documents that are outstanding. And I just want to just clarify a couple of points on that. So has anybody got anything further to say on Due to Cooperate? Because if you do, if you can raise your hands, please, that would be very useful. No, nobody's raising their hands or waving at me. So that's good. Invariably, there will be discussions in relation to housing needs and other elements that have been discussed today in our next sessions that are coming up. So I'm sure we will come back to this point, but obviously in terms of Due to Cooperate and the legal requirement to met, then we won't be discussing that again. What I wanted to just raise is the point about the update to the transport assessment. I just wanted to just raise that again, because I got the opportunity to have a chat with my colleague during the break, and we are a little bit concerned about the implications of that update, because we can't see it, we don't know what it says, we don't know what the implications are. We are a little bit concerned about when we are going to be able to see that. We fully understand the issues around the Lower Thames crossing and that, sensitive information, etc. But we really could do with understanding what the implications, because there could be implications from that for other sessions that are coming up. So it would be useful if, I know you're not going to give me an answer today, but if you could clarify when that would become available, or parts of it could become available. For instance, if there are elements that need to be hived off for sensitivity reasons, commercial sensitivity, whatever, or to at least summarise what the changes to that update are. We don't know how significant those changes are. That would be useful. I know that the County Council has said they don't think it's significant in terms of changing the Mr. Robinson mentioned that it doesn't think that it will completely change the outcomes of the transport assessment, but Mr. Robinson also said that there are still some gaps missing. So does that mean that further work needs to be done? And if so, how much will that delay the updating of this transport assessment? Mr. Shatlarevian.
Yeah, I perfectly understand your position, Ma'am. And what I'm going to do, or what we're going to do here, is see what we can do to speed up the process. And it might well be, actually, that a redacted version might prove to be of assistance, even if some further information might have to come to light a bit later on in the process. So leave it with us, and we'll see what we can do and try and give you an idea of time. I would hope to be able to come back to you on this at some stage tomorrow with an update, and to see if there's a mechanism we can use to bring forward information in advance of the full document, if that's possible.
That would be really helpful. I do appreciate you having a look at that. We were just a little bit concerned because obviously infrastructure is going to be discussed tomorrow in terms of the spatial strategy. I'm not saying that we will be discussing that document, because we won't, because it's not available, but it's the implications of that and whether it will mean, will we have to have a further hearing session on those particular matters. So if you can give me some form of commentary on that, that would be really useful.
We will do our very best, of course.
Thank you. Also, in relation to, I did say earlier about the the strategic locations document that's just recently been produced, and that's going to become, well, I think it's going on the website today. I will, through the programme officer, be in contact about accepting comments on that, etc., because obviously it's new evidence that's coming forward. So I won't give any timescales on that now, but we'll have a look at that because we need to look at exactly how big the document is, etc. But we will give adequate time for people to respond on that. Okay. Is there anything further that anybody wants to say on Duty to Cooperate? Because if not, then we'll be having a longer lunch period, which I'm sure everybody will be happy with that. And then we'll be starting again at 2 o'clock. So unless there's anything further anybody wants to say, I will adjourn this session or end this session for now, and then we will resume the hearing at 2 o'clock. Okay. Thank you very much, ladies and gentlemen. Thank you for your contributions. We will take your comments on board. Thank you.